Hello and welcome to Connected with Latham, where we discuss ideas, legal developments and business trends shaping the global economy. I'm Rob Moulton, a partner in Latham & Watkins' London office. In this episode, part of a 10-part series complementing Latham's 10 key focus areas in 2024 report, we discuss the direction of travel for retail markets in UK financial services. To discuss this, I'm joined by my colleague from the London office, counsel Becky Critchley. Becky, welcome to the podcast.
Thanks, Rob.
I thought we should start with the consumer duty because that's received so much coverage in UK financial markets. How much of a difference do you think the consumer duty has actually made to the way firms interact with their retail customers?
It's a great one to start with. And I think that question is actually really difficult at the moment. So we know through some of the work that we've done with our clients implementing consumer duty that it has been more than just a sort of TCF 2.0. There is more to it than treating your customers fairly. But whether or not in practice it changes the way in which firms will interact with their customers, I think is too early to tell. So we're really only 6 months into the implementation from the end of July. And we have another 6 months until boards have to give their first approval of the reports of how consumer duty has impacted the firm and whether it's been complied with. And also at that point, we have the application of the consumer duty to the closed book of products. I think at that point in time, we'll be in a really good position to think about whether it has made the positive changes that the FCA wants. The FCA also is clearly in information gathering mode as well. So we know that it has sent some letters out to consumer duty champions, to some CEOs to ask about some positive steps that the firms themselves think have been made. And clearly it's going to be using that information as part of its own work on the implementation.
And is there any insight, Becky, on from an early stage where the FCA's information gathering is focused?
So we know that it's been asking some initial questions, particularly around how firms have been approaching price and value, for example. So whether or not firms have then had to make changes to the pricing structures of products off the back of the consumer duty. One interesting point I think to note is the difference between the EU and the UK here, that FCA is very keen to stay away from being a pricing regulator, where we have some proposals in the EU which might look different from that. And so what the FCA isn't seeking to do is say set prices for particular products or particular services. But what it is doing is trying to monitor how firms are thinking about them to ensure that that part of the consumer duty is implemented properly. And that might involve a comparison piece across different types of firms for similar types of products.
So, Becky, what do you think boards need to focus on in 2024?
So for boards, they have this really onerous, in some respects, obligation to sign off on compliance once a year, this annual compliance report, which will be due at the end of July. And in order for boards to do that, they really do need to get on top of what firms' implementation look like, what the gaps look like, what have been the key focus areas and the key difficulties. So it's not going to be a sort of one-stop, we've looked at a report from the various business lines and we can sign off. It's much more nuanced and iterative than that. So it's what information are we getting? Do we think we've got the right information? Are there gaps in that information? Is consumer duty being raised at all relevant points in all of our board meetings? It shouldn't just be a line item on an agenda. It should permeate every aspect of a discussion. So clearly it should be on the agenda, but it should be thought of as a holistic approach to consumer duty and not just something that you tick off.
And that sounds challenging, Becky.
It's really challenging because it almost involves a challenging of the status quo in terms of the MI that firms get. So do we have the right information? And often you don't know what you don't know. So you don't know there's additional information out there that could help because you don't have the visibility at the business line level. But it's asking the question, so there is a gap here. Can we fill it? Do we have information to fill it? And if we don't, can we get it?
That's great. Now, Becky, I just want to change tack to the new Consumer Composite Investment proposals. Could you just summarise what is such an investment and what are the impacts for things that are caught by this regime?
So at the moment, it's not looking as groundbreaking as perhaps it might have been. So at the moment, a consumer composite investment is exactly the same as a PRIIP, where a PRIIP is a packaged retail investment product and the KID is the key information document that you have to provide to a customer where you're selling them a PRIIP. And just relabeled from a UK EU perspective. So we had hoped that when we saw the proposals that actually it would be more nuanced, so that it would perhaps exclude some things like bonds that have been subject of much discussion at market level before around whether or not that was a PRIIP. That isn't unfortunately followed through in the drafting. So at the moment, there's still a lot of industry work to try and provide some helpful feedback to the FCA on the proposals and to try and get things like that carved out better and better understood. But from a baseline point of view, it really is the same as a PRIIP at the moment. What we are hoping, though, is that there will be some simplification of the various disclosure obligations that we have in the current PRIIPs KID template. We know that the FCA previously has been quite critical of that and that there aren't so many movable features and that firms can't tailor them. And that's an interesting interplay with consumer duty. So we know that consumer duty has a consumer understanding limb. Firms have often then said, well, actually, we don't think the KID helps with consumer understanding because it's really difficult, it's really complicated. And it asked for some flexibility there, which the FCA had given previously. So we're hoping to see that kind of flexibility come out in the eventual new rules. But that really is a point that we're not quite certain where we'll land yet.
And do we think the FCA is in the mindset, Becky, of being flexible on these things? Is it listening to the industry?
This is probably one of the areas where they are, because we know that they have previously been critical of what was in existence and they have listened to the industry before by giving helpful guidance. But again, any kind of flexibility comes with risk. So you have that regulatory risk that then you have divergence among firms and different practices and divergent customer outcomes. So I think there may be a balance between the two for the regulators. What do we think we can achieve in terms of customer outcomes while achieving some form of flexibility for the market?
Great. And I just think about the consumer credit regime for a moment, another of those key retail areas. I mean, it's as old as I am. It must be overdue for reform, therefore. How extensive do you think the changes to the consumer credit regime will end up being under the current consultation for retail markets?
Yeah, so Rob, you're right. They've been around since the 70s, so quite a long time now, definitely long overdue in terms of reform. It's really unclear. So the proposals we have at the moment perhaps aren't indicating that the changes will be wide-ranging enough. A lot of the criticisms are that sort of the standard templates are too formulaic. They contain information that's not helpful to the consumer, and that the outcomes for breaching those requirements are too onerous. So, for example, you get a word out of place in a standard form document, that technically means that maybe your loan is unenforceable. That seems like a step too far. But it remains to be seen whether or not we'll get rowing back on that particular problem. Possibly unlikely, because it sounds like a rowing back on consumer protection, and outwardly that doesn't look like a place that the regulator wants to be. But hopefully what we will get is a greater flexibility in those rules with allowances for tailoring. And sitting alongside all of that, we have the proposals to bring buy now, pay later lenders into the scope of regulation. So we have a widening of the rules to capture those lenders, as well as a changing of the way in which the rules might operate for things like customer disclosures, and then alongside a tailoring perhaps of the conc rules to change the way in which firms operate in that space as well.
And those are important and sensitive markets to be playing with the rules, it strikes me, Becky. Are the industry engaged with government on these points? Is it full of lobbying, or are they waiting to see more about what the proposals are?
So it definitely has been, particularly in the buy now, pay later space. And there's a proposal there for a more light touch regime for those lenders, particularly bearing in mind that they are interest-free loans. So that's why they're currently, among other reasons, out of scope of regulation, but really bringing them in scope for reasons of affordability and those sorts of issues where customers can rack up quite a lot of buy now, pay later loans and they aren't tracked across the customer's loan portfolio, for example. So I think we'll see some lobbying on that space to make sure that those rules are appropriately tailored to that market. But perhaps what we won't see is wider lobbying around changing the regime wholesale. I think firms to some extent are accepting of the fact that that's where they are. And it's also hand in hand with the European proposals on consumer credit and the changes that are being made at European level, where there is already a significant amount of divergence, but that perhaps will increase over the years as we see the European proposals develop alongside the UK ones.
So we're stacking up changes in 2024 at the moment. Becky, we've touched on consumer duty, composite investments, consumer credit, and then changes to the regulated advice regime. Could you just summarise that for us and explain why further change is being made to what sort of advice can be given?
Yeah, that's a great one. And so We have further proposals here, really with a view to closing what both the government and the FCA perceives as the advice gap. So customers with a small amount to invest perhaps don't want a holistic advice service, so where it amounts to a full-on personal recommendation they have to pay for, but they might like a piece of advice in relation to a specific small investment. They don't need it on an ongoing basis. But that, again, the fees at the moment, and for firms taking on the regulatory risk of giving a personal recommendation is off-putting for firms, because firms won't take the risk of providing a personal recommendation for smaller amounts because the fees essentially don't justify it. So there's a proposal there to, one, clarify where the boundary between advice and information lies, so that firms might feel freer to provide information without crossing the line into providing regulated advice. There's also a further proposal to give what's called targeted advice, so that you might be able to produce advice that's suitable for a particular target market rather than a particular person. And that where you're satisfied that a person falls within that target market, you can provide advice. And you can see why that might be an attractive proposition. So a lower fee, because you're not having to examine people one by one to see whether that particular investment or recommendation is right for that person. It's right for a group of people instead. And so we'll see some further proposals on all of that during the course of this year.
So it sounds like a busy year for anyone involved in retail financial services in the UK.
Yes, and just to finally mention on that, we have the FCA's motor finance piece as well. So we're seeing an interesting development in the commission space on that as well. We have a first of a kind market-wide 166 there. So we'll see maybe some guidance that's applicable much wider across financial markets than just in relation to commission, but an interesting one to watch as well.
Well, thank you for joining me to talk about the direction of travel for retail markets in UK financial services, Becky.
My pleasure, Rob.
And thank you for listening to this episode in our Connected with Latham podcast series. You can subscribe and listen to new and archived episodes of Latham's podcasts on lw.com, Apple Podcasts, Google Podcasts, Spotify, or wherever you get your podcasts. If you'd like more information about the topics in this podcast, or access to our 10 key focus areas in 2024 report, please visit the links located in the show description, and do stay tuned for more episodes.
This podcast is provided as a service of Latham & Watkins LLP. Listening to this podcast does not create an attorney-client relationship between you and Latham & Watkins LLP, and you should not send confidential information to Latham & Watkins LLP. While we make every effort to assure that the content of this podcast is accurate, comprehensive, and current, we do not warrant or guarantee any of those things. And you may not rely on this podcast as a substitute for legal research and/or consulting a qualified attorney. Listening to this podcast is not a substitute for engaging a lawyer to advise you on your individual needs. Should you require legal advice on the issues covered in this podcast, please consult a qualified attorney. Under New York's Code of Professional Responsibility, portions of this communication contain attorney advertising. Prior results do not guarantee a similar outcome. Results depend upon a variety of factors unique to each representation. Please direct all inquiries regarding the conduct of Latham & Watkins attorneys under the New York's disciplinary rules to Latham & Watkins LLP, 1271 Avenue of the Americas, New York, New York, 10020. Phone number 1-212-906-1200.